My Lords, I rise to speak very briefly, partly because it's already past my bedtime, secondly because Noble Lords have already outlined some of the problems. It was a pleasure to hear the Noble Lord, Lord Renfrew, speak on this about archaeology. Well, I started a speech about 15 years ago when he was in the audience by saying that when I was a trainee archaeologist, he was such an icon, I thought he was already dead. So I'm absolutely thrilled. I'm absolutely thrilled to see he's still not dead. It's a pleasure, always a pleasure to hear him. I would like to put my comments in very simple terms so that members of your Lordship's House and the other benches can understand exactly what the problem is with the EU Withdrawal Bill on this issue. This Amendment 28, and by implication Amendment 26, is designed to make sure that we don't miss out on important parts of EU law, namely directives. EU directives place obligations on our government to act in particular ways, such as bringing forward particular pieces of legislation. And examples include the Working Time Directive, a social measure, and the Habitats Directive, an environmental measure. And so these directives cover a wide span of issues, and the current wording of the bill leaves huge gaps that these important directives could fall through. And so the amendments are seeking to plug those gaps and make sure that they're all brought over into EU law. And they also allow or require ministers to make sure that these directives are properly implemented so that we receive whatever benefits, rights and remedies were intended. And, of course, as has been said several times, the big problem with the current approach in Clause 4 is that it will exclude legal rights simply because they haven't been litigated on. I absolutely do not see the sense in this, and I'm sure the government is going to see that this needs a little bit of fixing and that we'll see some positive compromises come forward.